I asked him, I rolled my window down, and I asked him, I said, do you know Tay? He said, yeah, I know Tay. I said, who that is to you? He said, that's my girlfriend. I said, well, how you feel about her? He said, why are you asking me this? I said, I'm just asking because, you know, me and her have sexual relations, and I know you don't know about it. He said, man, why are you telling me this? I said, man, look, I'm just trying to just bring you, I'm trying to bring you to be honest with her and make her be honest with you. We having sex behind your back, man. You don't know about it.
Okay, everybody, and you know what time it is. It is time for another crazy Louisiana parole revocation hearing. And this man, I gotta tell you, his story, it just gets more wild as it goes. And anyways, let's just jump in. Thank you, Mr. Annan, for pointing out this hearing. I really, truly appreciate it. Let's go.
Terryance Russell, 13-11-88.
Okay. Do you have a questionnaire in front of you that you signed?
Yes, ma'am.
Okay.
Um,
All right. I see it. All right. Well, based upon the questionnaire, you're not eligible for appointed counsel. Just needed to let you know that. And then today, you don't have anybody speaking in favor or against you, support or opposition. And the person who is the lead on your case is Mr. Danny Barra, and I'm going to let him take over now. You're on mute, Danny.
All you got to do is laugh.
Okay.
I got it.
Okay.
It's alleged that you have violated the conditions of your parole number 4, in that you're allegedly engaged in criminal activity as evidenced by your arrest by the New Orleans Police Department on October 31st of 2022, where you were charged with stalking, aggravated assault with a firearm, and violation of a protective order. The charges of stalking and aggravated assault are pending with Arlene's docket for a trial on December the 9th, 2025. The charge of violation of a protective order was refused. How do you plead to that violation?
Not guilty, sir.
Not guilty. We're gonna ask you to make a statement shortly about it. Number 5, that you were in possession of a firearm at the time of that arrest by NOPD on 10/31, where you were charged with aggravated assault with a firearm. How do you plead to that one?
Not guilty, sir.
And that you didn't pay parole fees as ordered, and as of the date of your arrest, you were $2,975 behind.
Plead guilty to that, sir.
Guilty. All right, so let's talk about condition number 4. I'm looking at a police report, and several witnesses said you had a gun. Tell us about what happened that day that makes you not guilty.
Okay, sir. That day there, I want to say I want to start from the day before, but I'm going to start on May 6th. That said that I had a gun, and I texted her that morning, and hold up, they said the internet connection is unstable. What? You can hear me, sir?
Yeah, I hear you. You broke up a little bit at the beginning, but we hear you.
Okay.
Just talk loud and clear.
Yes, sir. I was doing Uber that morning at about 4:54 a.m. and I had texted Miss Johnson. I just said, hey, just to talk with her, because the day before I told her I wanted to break up with her. I didn't want to deal with her no more because she said that I made her feel uncomfortable. So I told her the only way for her not to feel uncomfortable with me is for me not to be in her life. So she was taking that as, I guess, by her texting me, what is up with that? And I didn't respond. So the next day, the next morning at 4:54 a.m., I just texted her, hey, to see if she was at work because she had to be to work for 5 o'clock in the morning. Me doing so, she texted back, she was like, I want to ask the board, do you have the text messages that I gave to Mr. Norman? Do the board have those text messages that I gave to Mr. Norman?
I haven't seen them.
The reason why I'm saying it like this, sir, the reason why I gave him the text messages is to show that I didn't stalk Miss Johnson, and I didn't have a gun in my possession, because the only communication that me and Miss Johnson had was through text messages. I didn't have no physical contact with Mr. Johnson. Only contact I had was with her boyfriend, and that is the reason why I gave Mr. Norman and Agent Paul those text messages to show that my communication and my only contact with Miss Johnson, the lady that said that I pulled a gun out on her, that I had a gun, was through text messages. There was no physical contact between me and her. There was physical contact between me and the boyfriend, because I'm the one that told him that me and her had a sexual relationship. And he got mad at that. But there was no physical contact.
Where did that contact with the boyfriend take place?
That morning, sir. That morning.
Where?
Oh,
Where?
At her house. At her house.
At her house?
Yes, sir. She was at work.
What were you doing at her house?
All right.
Y'all broke up.
Or I was texting her that morning to talk with her, to see if she was all right. By me and her having a discommunication, she said that I had a passenger, and by me having a passenger in the car doing Uber, we're not able to talk. But when she texts me to respond back to my text, when I tell her, hey, I also told her, because she tried to call me, I said, don't call me in 20 minutes. So when she said, I'm gonna call you now, I told her I got a passenger. So when she tried to call me, I told her call me back in 20 minutes, which she did. But at that time, I had picked up another passenger. And the lady that was in the car, when she tried to call me back, I said to the lady in the car, I said, why is she trying to call me? And she know I'm doing Uber. She know I got passengers. But the lady said that it was in the car, you can answer the phone. I don't mind. So when I answered the phone, me and her was talking. But she hung up the phone because she texted me. But where I said, well, you didn't have to hang up the phone because I was dropping the lady off in like 2 minutes. She said, yes, I did have to hang up the phone because I have bosses here. You don't. And then she was like, I can't take this morning. This is toxic. And that's when I text her. I said, well, look, since you feel that way, I'm going to tell your boyfriend about our, engagement. And then she was more or less like, why are you doing all that? You don't have to do that. And I'm like, yes, I do. And that's how I was around our house. And I was texting her saying that I'm going to make a video of the encounter. And when I was on her street, she stayed on North Tonti. As I was pulling up to her house to show her that I'm by her house, to let her boyfriend know that me and her is having sexual relations, just so happened he come outside and he was going with the young daughter to go drop off at school. As he was dropping off at school, mind you, sir, mind the board, I never had no encounter with him. It just so happened, he's bringing the young daughter to school. So he made a U-turn. Someone told me make a U-turn too in the middle of the streets. So when I made the U-turn and I pulled up, as he was about to go to the yellow and green house, I asked him, I rolled my window down and I asked him, I said, do you know Tate?
No parole for Tate.
He said, yeah, I know Tate. I said, who that is to you? He said, that's my girlfriend. I said, well, how you feel about her? He said, why are you asking me this? I said, I'm just asking because, you know, me and her having sexual relations and I know you don't know about it. He said, man, why are you telling me this? I said, man, look, I'm just trying to just bring you, I'm trying to bring you to be honest with her and make her be honest with you. We having sex behind your back, man. You don't know about it. So it was raining. It was raining this day. So he got out of the rain and stood on the side of the house to call her. Because I said, man, call her if you don't believe me. You could call her. So when he called her, he asked her, he said, why is this man in this white car asking me to call you? So when she said he trying to blackmail me, I said, why I gotta blackmail her when we having sex every day? And if you don't believe me, you want to see the text messages, the videos, and the pictures. And he was like, man, you better get from around here with all that there. And that's what made me leave. I left. And when I left, I went back to my house. And as I was at my house, Miss Johnson called me, asking me why did I went and told that man about me and her having sexual relations. I told her, I said, well, look, you play games with me. While I'm driving trucks, you telling me you want to be with me. But every time I come back to the city for us to get together, you telling me you can't be with me because you've been engaged with him for 2 years. You having a baby for him, a miscarriage of a baby for him, and that you want to be with him. But I'm saying, I told her, I said, well, since you want to try to be it to where you have a relation with him and you want to have me to give you money all the time, I said, that's why I went and told him. And that's why I gave the text messages to Mr. Norman to show the board. So when the board looked at the text messages, the board could see that our only communication was through text message and that I never possessed a gun. I never was arrested for a gun because I never had no gun and never used a gun. I knew better than to even much think about you was carrying a gun. And that will explain to the board how she's saying that on the day of the incident that I threatened via telephone, because that's on the police report. I threatened via telephone that I would shoot her and everybody in our house. So my thing was to show the board, that's why I gave the text messages to Mr. Norman to show the board that our only communication was through text messages, and nowhere in them text messages from 4:54 a.m. till 5:26 p.m. you would never read to where Terryance ever possessed a gun or Terryance ever threatened Miss Johnson or her boyfriend or her family. I never threatened no one. I never even much, or the only threat, I take that back because my lawyer said the only threat was of me telling her I was going to tell her boyfriend that me and her was having sexual relations. That's the only thing that is going to be said inside those text messages, not of me threatening her to shoot her. And then she said in her written statement for her affidavit for her temporary restraining order that I text that I was going to kill her boyfriend, and the 2 kids. She's saying everything that I said in the form of a threat was through text message. And I'm just wanting to show the board that I never threatened Miss Johnson. I have all the text messages. I gave her Mr. Norman, the man that had the preliminary hearing on me, and Mr. Paul, the agent, the parole officer agent that came to see me on August, what is this? August 26th. I gave them they made a copy of all my text messages, and I thought that they put it in the record so the board, this parole board, could see those records. And I see you saying, the board saying that they don't have those records.
We'll go ahead and accept what you're saying about the text messages.
Yes, sir.
As factual without them. So we don't need them. What you're saying explains it. But I'm looking at the police report. It doesn't say you text her. It says you threatened her by telephone.
Yes, sir.
No, that's not text.
Yes,
that's
sir.
not text. That's what she's saying. So I heard you say you were quoting the police report a while ago. it says that she reported that you arrived at her residence and parked outside her house, which you said you did, and threatened her by telephone, it doesn't say text, that he would shoot her and everyone inside the house, which what's being said here. Ms. Johnson stated that she looked outside the front window and observed you seated in a white Camry Toyota, which she observed you in the Florida license plate and observed you point an unknown model black handgun, which was wrapped in a red towel at her house. And she said that she has known Russell's since January of 2022 and involved in a relationship. Ms. Johnson said that Russell threatened to tell her current boyfriend about the affair. If she didn't have sex with him every day. Ms. Johnson stated Russell also threatened to kill her if the terms were not met. Kind of matches a little bit with what you were saying. And then the officer also writes that the boyfriend went to bring the kid to school, just like you said, and that you talked to the boyfriend, just like you said, and you asked him about the relationship with Tate.
No parole for Tate.
Just like you said. And this guy is saying that he observed while he was talking to you a red towel in the vehicle with a handgun sticking out of it. So that's the second person who says they saw a gun and that you had been passing back in front of the house, blowing up her phone. Now, I don't know what that means, whether texts are calling, but blowing up the phone. But then what's of more interest to me than those two statements are that the cops spoke to another witness on the scene, and the witness said that they observed an unknown subject in a white Toyota Camry who stated he was going to kick that door down and shoot him. It should be noted that this officer observed the victim coming from the neighbor's backyard where she had been hiding because she was scared. So that she says you have a gun, he says you have a gun, and then the neighbor says you got a gun. The only one who's saying you don't is you.
Okay.
That's where we at.
Okay. And sir, board,
Yeah.
that's why I asked that the text messages be brought up, because our only communication, she said I threatened via telephone. Our only communication was through text message. I did not call Miss Johnson. She only called me that morning. Now, as far as
you can't text a gun. You know,
that's why I'm trying to.
You told us you were sitting in front of her house. You told us that yourself. You were sitting in front of her house.
Talking to the boyfriend, sir.
And he says he saw a gun, and she says she saw you out there with a gun. And the neighbor says they saw you out there with a gun, and you actually talked to him.
Okay, sir. That's why I'm asking the board. I'm asking the board. The day of May 6, 2022, it was raining. All right. The boyfriend saying I had a gun sitting on the seat of the car. And he's saying he went and brought the daughter at 8 o'clock, 8:30. He went and brought the daughter to school, right? That's right there on the police report. That's what we, sir, that's what we going, board, that's what we going off of, right? We're going off of what it is said on the police report. All right. If we're going to go off of what's said on the police report, if he bringing the daughter to school, and if I'm there with him at 8:30, 8:30, approximately 8 to 8:30, the question being, sir, where was Miss Johnson? That's why I'm saying the text messages, listen to what I'm saying, sir. That's why I'm saying the text message is going to show Miss Johnson was at work. So the question being, how is Miss Johnson going to be at home for me to threaten her, for her to look out her window, to see me pointing a black unknown handgun, which was wrapped in a red towel, at her house if she was at work, sir. That's all I'm saying. The text messages will show that I was never in an encounter with Miss Johnson. Miss Johnson could never see me at her house because she was at work, sir. Now watch this here. Hold up, sir. Hold up.
But
Do
this
they
police
have-
report says she walked out the backyard. How was she at work and in the backyard at the same time?
That's what I'm trying to tell you, sir.
Yeah.
I never had an encounter with Miss Johnson. That's all I'm trying to get the board to see.
Okay, well, let me tell you, there are plenty of text messages that we have received, and they are very strong evidence of stalking and of your behavior towards Miss Johnson in threatening ways. And I've heard enough about how you didn't have any contact. You basically were holding her hostage for sex because you gave her money. And, you know, I've read enough of these text messages that I am fully convinced that you had a manipulative, aggressive behavior towards her. Okay. And that's what I need to tell you. I have copies of the text messages.
Okay, well, ma'am, I'm glad you brought that to the record. Where at in those text messages that I threatened Miss Johnson or her boyfriend?
Sir, you seem to have the wrong understanding of the level that we have to reach to find you guilty of parole violation. You were in my opinion, you were harassing and stalking someone who had a protective order at one point. I need no more evidence than that. I have it.
Ma'am, she never had a protective order. That's clearly in the records, ma'am. If you look at the stalking arrest record,
It's stalking, and I have evidence of your intimidating methodology in writing. Okay. I'm not trying this in the court of law. Understand me.
I understand, ma'am. I'm just asking the board. The context of the records is not of me being manipulative of Miss Johnson. If you read the context of the text messages, ma'am, I'm only saying that I'm going to tell your boyfriend.
Now,
I'm
listen
going
to
to
this.
take
This is you. I'm reading it. Tell him to come out. Tell him to come outside now. Tell him to come outside now. She asked, are you going to kill us, harm us? And then what part of FU you don't get? And then you go on. I mean, this continues. And then you cuss her some more. And then my people almost here. Tell them to look outside. I'm going to F your house, your family, and you. Tell him to come outside. This is from you, buddy.
I see.
So what part of that don't you understand that would make a person fear for their life? I mean, this goes on and on. You don't stop. Tell someone to get Josiah from that house. You thought I was playing. Let him know to come outside in 20 minutes. I mean, you even put a deadline on this.
Right, ma'am. That's what I'm saying. Ma'am,
Right.
I was at my house when I was texting Miss Johnson that was of me.
Tell them to come outside.
Ma'am, I wasn't nowhere around there. That's what I'm trying to ma'am, go back, go forward. I'm glad y'all are looking at the text. Go forward. You will see me once the encounter when I told her at 8:30, let him come outside. Tell him come outside at 8:30. What did I say after that, ma'am?
FaceTime at 8:30. You said you have 5 minutes before I get there to make a final
Right.
decision.
Right.
Every day or whatever. It
All
is
right.
your 8:30 is your deadline. As a
Okay.
matter of fact, FaceTime me at 8:30 so you can see that I'm playing or not, or real or not. Or FaceTime at 8:30. Pulling up now. Time's up.
All right. Keep reading, ma'am. Keep reading. Pulling up now. And what I say after that?
See, tell him I'll be back. That's what
All right. Stop right there, ma'am.
You know
That
what?
was-
That's enough of this arguing over this. I don't care to do this anymore. I don't know about the rest of the board.
I'll make a motion for executive session.
I second.
Bob Ross,
Yes.
Stapleton,
Yes.
Zadoo.
Yes.
Okay, the time is 12:20. We're back from executive session after discussing confidential matters. The panel is ready to vote, and we will start with Mr. Barra.
Mr. Russell, I find you guilty of violating condition number 4, number 5, and number 10, and vote to revoke your parole due to continued criminal behavior while on supervision that involves possession of a firearm.
My
Do?
vote, my vote is to revoke based on the preponderance of evidence of continued criminal conduct.
And I concur with my colleagues, and that concludes our hearing, and the time is 12:20.
And I think we all knew that that was coming. It's more of a surprise that they even had the executive session. It was actually, it was interesting that this parole board was even allowing him to dictate, with his strong language, and he had no tact. And it's like he thought that the parole board was maybe just another one of his girlfriends until it just shut him up. It was like, well, enough with this. This is his attitude is just shocking, and the way that he's, what it is though. I just the entire time I'm listening to him yell, I just put myself in the place of maybe anybody who he has gaslit his entire life. I mean, if you've ever been in an argument with someone who has mastered the craft of gaslighting, this man was it. He would just sit there and talk to you and insist, no, this is how it is. This is why you don't understand, and say it with so much like ego. Is that the word? So much. It's more than confidence. It's more like just, I'm right, you're wrong, you don't get it, you're stupid, and saying it so passionately. Now, I wish I had more information to share with you on this case. I mean, you look at the only name that pull up when I look on Louisiana was someone who was sentenced to life in prison for murder back in like the late 80s. This can't be. I mean, I don't know what he's initially, usually though, if they take an executive session and they take it like this seriously, where they just don't revoke, usually that is an indicator that the guy is backing an incredible amount of time. Like they usually give a little bit more, like in this revocation hearing, because if you just had a couple of years, they'd be like, but I don't know. I wish I knew. I cannot find. It's a black hole. And Sir Richard isn't as active as he used to be, and as Lady Holly, we haven't heard from her in months, unfortunately, and we have no updates, so I'm here alone. But Mr. Annan, who watches all the Louisiana hearings, said, Mandoo, you're going to want to check out this hearing. So thank you for shouting it out again. It was just totally, he's sitting there basically saying the gun wasn't mine, even though there are 3 witnesses. What was this? I mean, like, it was so insane. How could I have been there? Keep reading the text, keep reading, as if like he had some type of aha moment. But the aha moment never comes. It's never there. It's like, what proof is this? Oh, because I wasn't at the house. So how could I have but you were there, you just left. I mean, like, I don't know. It's totally bizarre. And it's like anyways, what can you do? You think about this, like the guy is on parole. Anything can get him revoked. And yet he had the audacity, it seems, to blackmail people, to threaten people, and all it takes for them is to just call the police. I mean, they can make their problem go away by just calling the police. And he needs to know that. He needs to understand that. He does. But he just didn't care. And again, I in these parole hearings and on Mandoo, my goal is to bring you more than just a hearing and to comment and, no parole for Tate. But I like to find the context, because I need to know the context and the information. How much, time was he serving? How much time is he backing? What is his initial crime? Like that is so important. But there's nothing here that I'm able to share with you. I'm so sorry. But let's jump into another crazy revocation hearing that Mr. Annan told us to check out. So let's jump in.
Yes, ma'am. Deputy Landry with the Jefferson Parish Sheriff's Office.
Okay, and so Mr. Hudson, for the record, will you introduce yourself with your DOC number, please?
Eddie Hudson, 767725.
Okay, do you have a questionnaire in front of you that you signed? Do y'all see that?
Yes, ma'am.
Okay, all right. All right, but according to your questionnaire, you're not eligible for appointed counsel. So you didn't retain counsel. So you ready to proceed?
Yes, ma'am.
Okay, thank you very much. Okay, today, your lead person is going to be Miss Jerry Ledoux. She's assigned your case. She's going to read out your violations and get your plea. And then you do have a supporter here, and we'll hear from your supporter. Miss Ledoux?
Yes, good afternoon, Mr. Hudson. I'm going to read the two violations you have against you, and I need a plea of guilty, not guilty, or guilty with a statement. On rule violation number 4, on 8/4/2025, the subject was arrested and charged with battery of a police officer and resisting police with force or violence. The charges are still pending, and you have a hearing, a plea hearing date of 10/16/2025. How do you plead?
Not guilty, ma'am.
Is there any reason to believe that you're not going to have your plea hearing tomorrow?
Can you repeat that, ma'am?
Do you plan to go to court tomorrow? Is that still planned?
Yes, ma'am.
Okay,
One of my charges had got dropped. The battery on the officer had got dropped. So it's just the resisting arrest that I had.
just resisting arrest. Okay. Number 6, subject is currently unemployed and has failed to be gainfully employed. Did you show proof of employment, or were you unemployed?
I was unemployed, but I was filling out applications. I told my PO to get documents for me, but she ain't never sent them to me. At the DRC, I was sending my case manager screenshots of interviews and stuff that I was doing.
Okay, so are you guilty or not guilty of failing to be gainfully employed?
Not guilty, ma'am.
Oh, Mr. Hudson, let's discuss the events that brought you to the arrest. We have a police report that indicates that you were seen hitting a female in a car, and police officer intervened, at which time you resisted arrest and fled. So tell me about that situation.
Yes, ma'am. I wasn't in there with a closed fist. It was an open hand, but I didn't hurt her as they said I did in the report, because that's my baby mother. So, I wouldn't put her in danger, and she had my child.
Okay, so it was just an open-handed hit, not a closed fist hit.
Yes, ma'am.
Okay. I'm holding back because I can't believe that you think that even an open-handed hit of a person would be acceptable.
Right. I know it's not acceptable, ma'am. I ain't say it was acceptable, but that was my fault.
Okay.
I had a quick moment, but I came to realization.
Okay. You were sent to the day reporting center in April, the 14th day of April. You tested positive for drugs, and 7/14, you tested positive for alcohol. Is that correct?
Yes, ma'am.
So you had returned to the use of illegal drugs and alcohol?
No, ma'am. That was the first time. That was the only time that I had got tested positive for marijuana. I ain't never tested positive again. And for the alcohol, I was drinking the day before.
Okay, so let's parse that out as well. Just because you didn't get tested positive, but were you still doing marijuana on a fairly regular basis?
Occasionally, but I wasn't doing it every day though.
Okay, but you knew that the use of, okay, in Louisiana, it's still illegal. Okay, so
Yes.
you knew that your parole required you to not have anything to do with illegal drugs.
Yes, ma'am.
Okay, all right. I have no further questions. If my colleagues have some.
I don't have any.
What was the fight about in the car with your baby mama?
Sir?
What was the fight about in the car with your baby's mother?
Oh, I had went through her phone and I had saw something.
You
And
saw
we
something?
just started arguing, and you know, she just clicked out on me. And I had my little quick moment.
And then why did you run away from the police?
Because I had to go to court. Well, I had court, but I missed it. And in my division, I know how my judge is. And like my sister said, I just filled out for the construction program, and I had to go to that interview. So I didn't want me to come to jail and miss it, even though I still did. I thought I would, you know, when I came to realization, I stopped because I was only gonna make things worse for myself.
So the court that you had didn't have nothing to do with this. It was something else.
No, it was fines and fees, but they had an attachment out on me because I forgot my court date.
Right. That's the only questions I had.
Okay, is the panel ready to vote?
I am.
Okay, we'll start with Ms. Ledoux. She has the lead in the case.
Mr. Hudson, I would strongly encourage you to examine your behavior on parole. My vote is to revoke you. You admitted to hitting a person with an open hand and also to doing marijuana and alcohol, which are both prohibited on your conditions of parole. So my vote is to revoke.
Okay, Mr. Barra?
I'll concur with Ms. Ledoux for the same reasons.
Okay, and I'll concur with Ms. Ledoux for the same reason. So today, sir, you've been revoked, and it is for hitting another person with your open hand and for illegal drug use. So that concludes our business at Jefferson Parish Correctional Center, and it is 2:18.
Did you see the look on Miss Stapleton's face, who's the Louisiana victim advocate, when he said, I just hit her with an open fist? And I love that Miss Ledoux gave him a proper scolding for that. It's crazy to think that somebody they're so in their own world where they still don't even see that is wrong. Well, it's an open fist. It wasn't a closed fist. I don't know. It's true though. It's become so normal to just hit your significant other. It's like, it's just so normal these days. But again, I have no information on this case, but I do have information on the case that we're about to watch. Again, thank you, Mr. Annan, for bringing this up. This man whom we're about to see was locked up for a murder that took place in 1995. He shot a man twice in the head over what just appears to be some random argument. I can go over the informations of the appeal in this case, but to think he's definitely backing life, and now here he is facing a potential revocation. Let's jump in.
Name is Clemone L DOC number 387876, ma'am.
Okay, do you have a questionnaire in front of you that you filled out that's got your signature?
Which?
If you don't, they can put it on the screen. Look on the screen and it'll be.
Oh,
up
yes,
there.
ma'am, I have it.
Okay, all right. So according to the questionnaire, I know that you hired an attorney to represent you and you're not eligible for appointed counsel, but you did retain counsel, correct?
Yes, ma'am, a family member obtained one for me, ma'am.
Okay, Mr. Maynard Baptiste?
Yes, ma'am.
Okay, well, today the person that is the lead panel representative is Mr. Danny Barra. He's been assigned your case. He will review your violations. Mr. Bauer, did you want the attorney and the supporters to speak first, or do you want to speak first? Okay.
They can go ahead and speak first.
Okay, all right, we're gonna let the supporters speak first. It's the cousin, Ms. Mandoo. Would you go ahead and speak and say what you would like for us to hear? Is she on?
I don't think she on
Yes, I'm on.
Okay. All right, you can go ahead and speak to us, please.
Yes, ma'am. I just wanted to say that I was at the house when this incident was supposed to happen, and I just wanted to let y'all know that it went on.
Can you speak up?
Yeah, can you speak up, ma'am? We're having a hard time hearing on the board.
I was trying to say that I was at the residence when this incident happened.
If she's on speakerphone, maybe that might be a problem.
Are you on speakerphone?
Yeah. Hear me?
Yes, ma'am. Try breaking up real bad. Okay, she's trying to reconnect. Okay, do you want the attorney to speak while we're waiting? They don't.
Go ahead. Let the
Yeah.
attorney speak.
Okay,
Can you hear me now?
Better.
yes, this is better. Yes, ma'am, go ahead.
I was just trying to say that it's at the residence when this happened, and I just wanted to let y'all know that Clemone didn't do her anything. I'm not sure where she came from with this story, but my sister, she's been dealing with a lot because the victim is my sister, and I took her in, and she done made up a bunch of lies, and she been lying on a few people, and I just didn't want him to get violated for something that he didn't do.
Mr. Byron, do you have any questions of,
No questions.
He was at the residence. That's what he didn't hear.
yeah, she was at the residence. Yeah,
She was
Yeah,
there.
when it happened. Yes.
was there.
Okay.
Okay. All right, now, Mr. Baptiste, will you speak to the board, please?
Yes, good afternoon. I would like to say good afternoon to Ms. Stapleton. Is it Ms. Mandoo and Mr. Bauer? My name is Attorney Maynard Baptiste, and I was trying to be as clear and succinct as possible. I don't have the Zoom like this morning. I was having problems trying to log into the meeting, so I apologize that I have to participate in the call. Can you hear me very well?
Hang on 1 minute. Okay, go ahead and speak. You can go ahead and continue.
Yes, ma'am. I was trying to greet each of you and to apologize that I'm not able to participate by Zoom. I don't know what happened. I was able to register this morning, but when they gave me the ID number, it didn't work this afternoon. So I'm trying to participate by phone. So I wanted to start off by saying that what I was respectfully asking you to do, I think the witness just said it. We were asking you respectfully to not revoke Mr. Ledoux's parole. And I have 4 very pertinent reasons. The one main reason is that the judge saw fit to relieve my client of his bond. On April the 14th, 2025, we were set for a jury trial in this matter, and the judge relieved my client of his bond because the state, the district attorney, Mr. Unhinged, decided to pass this case without date because he knew when he had the evidence with regarding the rape kit test, it came back with insufficient evidence against my client. And 2, in November of 2024, November the 19th exactly, I think even his parole officer, Ms. Dixon, gave you a copy. The alleged victim filed a drop charge for him. So going back, this all started with a so-called grand jury indictment. They were trying to indict my client on first degree rape. That did not manifest, so they dropped it down to so-called sexual battery. This case was set for trial 2 times, and on the second version, as I already reiterated, the state decided to pass it without date, and the judge relieved my client of his bond. So the only reason why my client is sitting in jail is because I think he has the parole hold by your office, and we respectfully asking you to lift it. The judge saw fit that to relieve him of his bond, and the state saw fit to pass this case without date. So what I did, trying to represent him zealously, didn't want Mr. Lemone sitting in jail because the state was never going to set this for a trial. So I moved for what they call a motion for a speedy trial to have it put back on the docket to see if the state would just go on and dismiss it based on two things. One, they originally passed it without date, meaning that they knew it was not going to ever come back to trial. They asked my client to waive his right to prescription, and then she tried to drop the charges against my client, Mr. Landoo. So what we have first is the grand jury indictment started off with a so-called first. That didn't manifest. It went down to sexual battery. When that didn't manifest, when they couldn't try my client based on the information that they had, which was a so-called test, they decided to pass the case without bail, and the judge relieved my client of his bond obligation. So I'm asking you respectfully to allow my client to go on with his parole. Two, like when I read your probable cause, you said that he had violated certain condition of his parole by having criminal activity. That has not been substantiated. In fact, that has been negated by the fact that, as I said, the state decided to pass this case without bail, and the judge relieved my client of his bond. Then she tried to drop the charges. So I am the one who asked him to bring this to trial so I can get these charges dismissed against my client. Lastly, you also, in the bill of particulars, I think, and you found him probable cause for not paying fees. But what happened when your department decided to respectfully grant him a parole in 2015, my client went back in 2016, 17, he got 3 degrees from the Baton Rouge Community College. He was employed at Dow Chemical from 2016 to 2018. Then he got employed at Turner Industries, where he sustained a back injury. And I must apologize to the board. I did not have an opportunity because I'm a public defender and I'm working on a case that's supposed to go to trial next week. I could not get the HIPAA form signed by Mr. Landoo, so I could get you the records from Dr. Crosby. My client has had 6 surgeries regarding stenosis on the back of his spine. That's why he was back on his a little in arrearages on his fees, because up until then, I don't think Mr. Ramagas, his parole officer, or Mrs. Dixon had any problems with my client, Mr. Landoo, paying his fees. So what I'm saying that he was basically caught up with everything until he received this injury with his back, and he started receiving these surgeries from Dr. Crosby. So with regard to the 2 allegations of him violating the conditions of his probation, my argument to you with evidence is that Mr. Landoo has not engaged in any criminal activity, and that can be substantiated by the fact that Judge Laurie relieved him of his bond, and the district attorney decided to pass this case without bail. So he is just sitting there in jail because there's a parole hold on my client.
So what are you asking for? What are you asking us for?
I'm sorry.
What are you asking us for today?
I was asking you not to revoke his parole, to allow him to, like, if you could lift the hold so he could get out. I think he has, I don't know, with his surgery, he may have another surgery procedure scheduled. And the rearages, he needs to get back to work so he can catch up on those fees. So I'm asking you respectfully, based on that information, not only, if you read the report from Mrs. Dixon, you'll see that the rape test came back insufficient, as well as the fact that she tried to drop the charges. I think I gave Ms. Dixon a copy of that drop charge form. So I'm respectfully asking you, Mrs. Stapleton and Mrs. Landoo and Mr. Bada, to lift the hold so my client can get out of jail, get himself back into the workforce so he can pay off his fees. And I can assure you that this matter will be dismissed. That's what I'm asking you respectfully to do.
All right, I'm going to ask for an executive session.
I'll second.
Mr. Bada, was that you speaking?
Yeah,
Yeah.
we're going into executive session. Hold on, let's put it on mute.
You can start.
You can respond to tell me going into executive. Okay. Mr. Baptiste, we're going into executive session right now to discuss confidential matters.
Yes.
Speaking that he asked me what I wanted. I also wanted to see, besides asking you respectfully to lift the hold, if they would grant him a continuance until I can get this matter dismissed. I think that was listed in one of your procedural papers that I received. You can also ask for a continuance.
He wants a continuance?
That's what he's asking for. A continuance.
Okay.
as well as see if they can lift the hold.
Continuance and lift the hold.
Yes, ma'am.
All right.
Okay, hold on, we're going into executive session.
Yeah.
Yes, ma'am.
Yes.
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 Wow. So normally I just like cut in through the executive session and put in writing how long it was, but this was a nearly 1 hour, like 50-odd minute executive session, which I frankly, it's a record. And maybe they were going out to lunch, but I've never seen that happen before. Really, I do think this is the longest executive session by a long shot. So they're really trying to get this right. Remember, he's backing life. So there is a lot on the line. I appreciate that they're taking the time to dive into this. And now let's jump in. Let's see what they do.
Okay, we're back from executive session and the time is 3:21. Mr. Barra, are you ready to vote? What is your question, sir? You're on mute.
May I be allowed to speak on my behalf?
Go ahead.
I'm here today because of what I have said, nothing that I did. I did nothing to this young lady physically. Did I say some things that may have hurt her feeling about the path she was taking while she was at my residence, or what was overheard from her sister, or what she may be doing with her new girlfriend in the streets in the Plank Road area? Yes, I did. I used a form of unconstructive criticism that I used to use when I taught the youth program at DCI, when I done served 20 years. And was it effective with the young lady? Obviously not. But I don't deserve this. I have a fiance. I've been out there. I worked. I got degrees. And when I went through my back pains, I didn't go in those corners or sell no drugs. I didn't do no crimes. I waited it out. When I was broke and hungry, I didn't do anything. When I was able to do something with my hands to make $1, whether it was taking some kids to school or painting some cabinets, I did it. I'm hurting in here. I just want my freedom. I don't deserve this for trying to make someone see the path that they were headed down. She's headed down the wrong path. And I watch the news daily and I say to myself, I see why the crime rate in the youth is so high. It's hard to talk to them. They won't listen. I'm not that type of person, and I never will be. I come to the point now, after this, that I just have to mind my business. I'm a convicted felon on parole, and whether I want to help somebody to make a better decision, I just have to mind my business, because after this situation here, I'm afraid. I'm afraid. I just want to go have my operations, get back with Turner and get my position, pay my fees, and live the rest of my life out. I don't want this, and I never did. Thank you for hearing me.
Yes, sir. Mr. Barra?
All right. We're ready to vote. We received information from the district attorney's office that the charges were not dismissed, and you still got a court date on November 17th at 9 a.m. to determine guilt or innocence in that charge. So what we're going to do, we're going to grant part of your attorney's request, and that's going to be, we're going to continue this hearing until the outcome of the pending charges. Now we'll give you a chance to defend yourself and then come back with it called dismissed, if what he's saying is all going to work out.
Yes, my vote is to continue until the disposal of these charges.
Okay, and my vote is to continue pending out trial. So today, sir, your hearing has been continued until the pending outcome of the trial. And that will sign us off at this location. at 325 at West Baton Rouge Parish Jail. That concludes our business today.
Thank you. Thank you, sir. Thank you, ma'am.
And I am happy that we caught that hot mic at the end of him taking a deep sigh of relief, because I was almost curious if, did he really just want to get released by parole? But I mean, this makes a lot of sense. Look, this is what it means. He had gotten paroled, as we can hear in the meeting notes, in 2015. He was serving a life sentence. We'll go over through a little bit of that appeal just to give some more context. And now he's caught up and accused of this horrible crime, which it seems that the prosecution doesn't have their act together, right? To the point where the judge actually lifted the bond requirements. So prosecution's not following through. They don't have enough evidence, or it's not looking good for them. And he has an attorney, a public defender who it seems is saying, hey, we're going to take this all the way to court. This guy's a success story. These are all bogus allegations, and here's why. Even the judge lifted up the bond. So what we would like you to do is just let my client go. He's been locked up for this long, or at the very least do a continuance. And why is a continuance so important? Because we have seen hearings where the board did not give a continuance. We have seen hearings. And this is for the porch pirate. For those of you who remember that hearing, this man also had a life sentence. He was caught stealing one Amazon box from his neighbor. He was caught on the Ring camera. They had that evidence. And the parole board, and he was going to court that afternoon. He was actually taking his parole hearing from the courthouse, parole revocation hearing from the courthouse. And then later that afternoon, he was going to court. And he was saying, hey, just let me go to court. What if I'm found not guilty? And the parole board said, we have the Ring camera. We have the police reports. We actually don't care. You're getting revoked. And the guy was revoked before he had his court hearing. So he's so grateful that he's giving a continuance, because it gives him another chance at life. He might be stuck in a system for a whole bunch of years. I mean, eventually he can file certain motions and say, what you're doing is unconstitutional to keep me locked up for so long. We have to we're going to trial now, or don't go to trial. And then the prosecution's going to have to figure out how they're going to prosecute the case or not. But it means that now he's got another day to live, and he knows that he can fight till after the court case. And then what is going to happen, we'll see him again. And you can come to the return of playlist when we do see him. And he's going to have a revocation hearing where they're going to go and say, okay, well, he's going to say, hey, they took me to trial and I was found not guilty. Or they're going to say, prosecutors, they just dropped all the charges. And then it's going to be up to the revocation board to say whether they're going to revoke or not. But he's not scot-free even in that circumstance, because we covered a revocation case after the man went to trial, after he was found unanimously not guilty by a 12-person jury. But the parole board saw the evidence of that case and said, we are not drinking the Kool-Aid that your jury drank, because it's absolutely insane. Basically, they had DNA evidence on the case, and the DNA evidence said it was him by a statistical chance of like 1 in something the number of quadrillion. Yet this guy's public defender was still able to convince the jury that there was still a 1 quadrillion in chance that it's not his DNA, and the jury found him that. Here, I'll play a clip for it if you haven't seen it, and it's insane enough that you should go. Okay.
But what I'm trying to say is, if you take a DNA sample to do DNA analysis, if it was my DNA, it'll say 100% match. It wouldn't be a mix-up. It could be my DNA. If you take a DNA of yourself right now, and they'll say, okay, it's your DNA. It wouldn't say it could be or it's possibility. Same way my lawyer explained it in trial. That's why I was proven not guilty by 12 jurors.
And you see, I mean, it's insane. It's totally insane, right? So in this case, the parole board actually said, even though you were found unanimously not guilty, we're still revoking you. So he and you could, I'll leave a link to this hearing in the description if you haven't seen it. It's not gotten the views it should get. I think it's just an incredibly fascinating case. But so he's still not scot-free. He could still, the parole board might still revoke him even under the circumstances. So he's still got a long way in his battle. Now, this is the case that he was initially locked up for. So as you can see, it was the appeal was decided in 1999, and it happened in 1995. So he served 20 years for this homicide and got out on parole. And it says that on June 30th, 1995, the defendant shot the victim twice in the head after an argument where the men cursed at each other in front of the defendant's home. Prior to the shooting, the victim had argued with the defendant, backed his car into the defendant's driveway and opened the car door. The defendant then reached through the passenger side window of the victim's car and pointed the gun at the victim's head. The victim told the defendant to shoot him, and the defendant shot the victim in the head. This is like, in the movies, you see people be tough guys and they're like, yeah, you don't have the courage, shoot me. And it's like, okay, boom. And then like your life's over. The movies don't typically play out that way, right? They play out more like the guy doesn't shoot. After a pause, the defendant shot the victim a second time in the head. Like, this is just not a good. After shooting the victim, the defendant drove off in the victim's car with the victim's body in the car and dumped the body in a field. The defendant was arrested after being stopped by the police. Prior to the date in question, the defendants and the victim were acquaintances but had disagreement regarding a car owned by the defendant but sold to the third party of the victim. Michael, who was shot in the front passenger seat of the vehicle when the victim was shot, testified that the victim did not reach for a gun and did not see the victim with the gun that day. Oh, he was in the front seat with the victim when he was shot? Holy cow. Gerd Thomas, who was also in the victim's car at the time of shooting, testified that he did not see the victim with the gun that day. There were two witnesses in the car. Oh my God. So this is someone who has impulse controls, who had no problem murdering someone for no reason in front of witnesses. Like, it's just hard to give him credit. Like, it seems like that he has done well, so to speak, and he was talking, but it's just, how do you trust someone who has done that kind of violent crime? But let's see how this plays out. We'll keep an eye on it for you. And for those of you who are familiar with the channel would know that that's not a blank statement. We cover hearings that goes far back as we have access to, which is 5 years. We've covered people who have been paroled in 2020 and then get revoked 5 years later. So check out the return of playlist if you want to see hearings like that. And please, the algorithm has changed. So what makes the biggest difference is hearing your comments, commenting on the case. I don't ask for this. I haven't been asking for it, but I've been told that that if you don't have that type of interaction, the channel will die, and the channel has been suffering a lot, and it's difficult. So that is something that you can do to help keep me motivated. And thank you again, Mr. Annan, for pointing out these hearings. If any of you listen to a hearing that you think I should cover, please email it to me with the link. The timestamp really helps, and some context, and I'll love to give you a shout out. And with that, I'll let you go.
I use a form of unconstructive criticism that I used to use when I taught the youth program at DCI, when I done served 20 years. And was it effective with the young lady? Obviously not, but I don't deserve this. I have a fiance. I've been out there, I worked, I got degrees, and when I went through my back pains, I didn't go in those corners or sell no drugs. I didn't do no crimes. I waited it out. When I was broke and hungry, I didn't do anything. When I was able to do something with my hands to make $1, whether it was taking some kids to school or painting some cabinets, I did it. I'm hurting in here. I just want my freedom.